This is the story of two families' fortunes. Both sets of parents wanted their children to inherit their accumulated wealth in a way that ensured minimal risk and maximum benefit. One family relied on a simple will. One family relied on modern estate planning. Both families got exactly what they paid for. Welcome to the convenient truth about modern estate planning. Did you know that most simple wills prepared by a local or family solicitor, or prepared using a post office will kit, only cover assets you personally own, such as the family home, investments, and cash, and say nothing about the assets controlled by third parties, such as super, life insurance, companies, and trusts? Even owned assets, by and large, remain at risk. These simple wills normally leave a family's inheritances exposed to unnecessary taxes, costly disputes, and the exposure of inheritances to divorce or bankruptcy. Let's look at how. Introducing Mr. and Mrs. Wishful. Unfortunately, they passed on to their 4 children a terrible mess thanks to their simple will. Like most busy couples raising a family, they were quite happy with themselves for having a will of any kind, unaware of the dire consequences that lay ahead for their beneficiaries, B1, B2, B3, and B4. By the time they passed on, Mr. and Mrs. Wishful had accumulated an estate worth $2 million, leaving $500,000 to each child. More than enough to set each child up with a significant nest egg. Unfortunately for B1, B2, B3, and B4, it was not to be. In Scenario 1, B1 invests the inheritance he now owns and receives a return on the investment of $50,000 per annum. As B1 already has a good income from his job, the income on the inheritance is taxed as additional taxable income, resulting in the ATO taking 40%, or $20,000 each year in additional tax, making B1 very frustrated indeed, and the ATO an additional and ongoing beneficiary of Mr. and Mrs. Wishful's estate. In Scenario 2, sadly for B2, her marriage fails and divorce proceedings commence. Unfortunately for B2, the family court sees her inheritance as being part of her family's wealth and allocates 50% of the inheritance, or $250,000, to her ex-spouse, leaving B2 extremely saddened at the loss of her parents' parting financial gesture. Scenario 3 demonstrates how Mr. and Mrs. Wishful's simple will does not protect their children's inheritances from bankruptcy, which can be caused by any number of common reasons, such as business failure, gambling debts, being sued professionally, or an addiction. When B3 is declared bankrupt, his $500,000 inheritance is simply seen by the bankruptcy trustee as part of his assets, and thus taken with everything else he owns and used to pay creditors. All 100%. Ouch. Sadly, the premature death of both parents through accident or illness is not an uncommon possibility. Should this happen when B4 is still a full-time student, and her older siblings are all working full-time, she would be the Wishful family's only tax dependent. Because of Commonwealth superannuation law, B4 would almost certainly receive their entire $500,000 super death benefits, in addition to her equal share of the remaining estate. In this scenario, B4 would receive $500,000 more than her siblings, leaving B1, B2, and B3 very unhappy, and the Wishful's hopes for the inheritance being equally shared in ruins. Another common problem that arises from an inadequate will is the issue of loans. In this scenario, Mr. and Mrs. Wishful had given their oldest child, B1, $100,000 to purchase a house, which was never formally recorded. Unfortunately, the parents' untimely death meant that this loan was left unaccounted for when the estate was distributed, leaving B2, B3, and B4 feeling cheated by their parents and by B1, and any hopes for inheritance equality in ruins once again. So, let's sum up the Wishful family's fortunes from relying on a simple will prepared by a non-expert in estate planning. The income gained from the inheritances was taxed at maximum rates. The inheritances were left open to legal seizures due to divorce and bankruptcy. Inequality occurred, caused by both superannuation law relating to tax dependents and by loans made to children pre-death, all of which led to a much higher occurrence of unnecessary disputes, litigation, and smaller inheritances. Now let's meet Mr. and Mrs. Prepared. They met with the estate planning experts at RetireLaw. Like the previous family, they have an estate worth $2 million and 4 children whom they also wished would share their estate equally. However, the outcome for the Prepared family was very different, as they suffered none of the problems that plagued the Wishful family. Why? The answer is simple. RetireLaw's modern estate planning wills gift-wrapped the inheritances in a way that offered advantages the Wishful children missed out, via cutting-edge, individual, beneficiary-controlled testamentary trusts, whereby each beneficiary gets their own individual trust with which to control, protect, and maximize their inheritances. Each beneficiary has the option to retain their inheritance in a trust, or not, and as trustees of their own trusts, each beneficiary has complete discretion as to how and with whom the funds within the trust are shared and enjoyed. Now, let's take another look at those real-world scenarios that cause so many problems for the Wishful family. With the benefit of RetireLaw's beneficiary-controlled testamentary trust, as trustee of his trust, B1 of the Prepared family invests the trust assets, his inheritance, and the trust receives an annual income of $50,000. B1 as trustee decides that he does not want to increase his own taxable income, so elects to allocate the income to his 3 children as allowed under the Tax Act, with each child treated as a tax-paying adult, even if under 18. The income they receive from B1's testamentary trust can be used for their education and other expenses, and any tax payable will be minimal compared with B1's 40% tax rate. A much better result for the Prepared family. In scenario 2, when B2's marriage fails, because the family court does not normally make orders against testamentary trusts, B2's inheritance is secure, leaving B2 a very happy beneficiary. Also, no matter what the reason, when B3 is declared bankrupt, assets held in a testamentary trust are protected from bankruptcy. In this case, a very relieved B3. Like with the Wishful family, B4's status is as a full-time student and tax-dependent for superannuation law purposes. However, provisions in Mr. and Mrs. Prepared's will ensure that the executors are required to take such a payment to B4 into account, so that as far as possible overall equality is achieved. In this scenario, while B4's share is likely to consist mainly of his parents' superannuation death benefits, B4 would no longer be $500,000 better off than her siblings. Likewise, these adjustment provisions in the wills of Mr. and Mrs. Prepared also take account of any loans made to their children prior to their passing. This ensures that equality of inheritances is protected and avoids the need for any unnecessary disputes between siblings, which invariably lead to an erosion of the estate, not to mention the negative effect on family relationships. Another important advantage to the Prepareds of having a modern estate planning will from RetireLaw is that should a beneficiary have a particular wish to inherit the family home, provisions are included in the will granting a right of occupancy, thus allowing a beneficiary to receive the home via their testamentary trust without capital gains tax or land tax problems, provided that they're going to use it as their family home. Just as with other inheritances in a testamentary trust, the house is protected from the impacts of divorce and bankruptcy and does not give rise to negative tax consequences. As you can see, RetireLaw's modern estate planning service offers tremendous safeguards for inheritances and substantially reduces the risk of disputes and litigation. In summary, these advantages include protection of inheritances from unnecessary taxes, divorce settlements, bankruptcy, litigation and disputes, as well as protection provisions for child beneficiaries and vulnerable beneficiaries, protection from high estate distribution and administration costs, protection provisions to ensure inheritance equality if desired, protection of business assets through safety net provisions, and protection provisions for superannuation, assets in trusts, and life insurance payouts. and RetireLaw's modern estate planning wills cover the entire estate, both owned and controlled assets, including directions to executors regarding all asset classes, and right of occupation provisions for the family home. Additionally, only direct bloodline family members inherit, and a beneficiary's trust can pass down to their children and grandchildren for up to 80 years. For many families, of great concern is the ongoing health and welfare of beneficiaries they consider to be vulnerable. This could be because of their age, an addiction, an illness, a disability, or simply because they are not good managers of money. All RetireLaw wills include a specified qualifying age stating when beneficiaries are to control an inheritance. Crisis provisions are also included in all RetireLaw wills in case a beneficiary becomes vulnerable later in life. Special protective trust provisions are included, when necessary, for beneficiaries with little or no likelihood of ever being able to manage an inheritance. These preventative measures ensure that the long-term financial security, health, and welfare of any vulnerable or at-risk beneficiary is seen to in the most appropriate, sensible, and sustainable way. All clients of RetireLaw's Modern Estate Planning Service receive Modern Estate Planning Wills, offering beneficiary-controlled testamentary trusts to protect and maximize an estate for your nominated beneficiaries. Enduring powers of attorney, with primary and substitute appointees, to protect your interests should you or your partner suffer a debilitating accident or simply no longer be able to look after your own affairs. And appointments of enduring guardian with primary and substitute appointees to ensure that should you lose capacity, your appointees have legal authority to make decisions on your behalf regarding your welfare, housing, and medical treatment. RetireLaw's fee also covers safe custody of your wills, registration of your will's date and location with the wills registry at births, deaths, and marriages, so that your family will always be able to locate a will. A portfolio containing copies of all signed documents, together with a plain language, clause-by-clause explanation of the wills, and explanatory material covering each document category, plus all relevant instructions, so as to ensure that each client of RetireLaw fully understands the manner in which their particular estate will be distributed. As with your own life, with its changing circumstances and fortunes, a will is, in essence, a living document, and should be updated as your life or circumstances change. Relying on a simple 2 or 3 page will prepared some years ago to do this for you will almost certainly result in serious and unnecessary problems and substantially reduce inheritances for your children after your death. Can you really afford to leave your estate up to chance? Speak to the experts.